v. Russian, case number 14-10018-01. May I have the appearance of the defense, please?
James Russian appears in person and through counsel David Friend, Assistant Federal Defender.
Thank you, Mr. Friend. We have this case on the docket today on the issue of detention, and then for arraignment. We'll take up the detention question first. Mr. Metzger, how would you like to proceed?
My proffer, Your Honor.
Please.
Your Honor, the United States is going to approach this by historical and then the date on which led to the instant charges. Historically, the defendant has 2 prior convictions for involving narcotics, specifically in July of 1979 and then in October of 1988. He has 2 prior convictions for violent offenses. November of 85, his conspiracy to commit aggravated battery, for which he was convicted, and then he was again convicted for assault in April of 06. In addition to that, the defendant has an aggravated assault on a law enforcement officer arrest. The investigation did not reveal the results of that, as well as an April 2004 resisting arrest charge, and then a June 2006 charge for aggravated assault. Again, we don't know the dispositions of that, so at the most they would be arrests without convictions. Additionally, Your Honor, the defendant has 1 prior conviction for being a felon in possession of a firearm, which occurred in May of 1986. And we have 2 different instances of flight. He had a fleeing law enforcement and obstruction of legal process in April of 2006, which led to conviction for the obstruction of legal process. And in March of 2011, he was charged with and found conviction with violation of the protective order. There was not a conviction on that. There was a deferred prosecution, which led to a eventual dismissal after he successfully completed the deferment. That leads us to the incident that led to the defendant's current arrest, which occurred in November of 2013. Your Honor, this incident was an incident in which the defendant apparently left a firearm and drugs at a lady's residence in Joplin, Missouri. He realized that had occurred and called her on the phone, as well as sent her various text messages concerning his gun and his drugs, and some sort of altercation erupted at the lady's house, and the defendant picked up the firearm and pointed the firearm at the 2 women that were present in the residence. They called the police. The defendant then left, and the defendant's vehicle was intercepted by a police car. The defendant failed to stop until many miles later. During that time, he was seen throwing items from the car, and as a result of the defendant's eventual detention that night, a search warrant was obtained. During the execution of this search warrant, they found the firearm that's referenced in the instant charges. In addition to that, they found liquid methamphetamine.
The firearm was found during a search of the car, is that?
No, the firearm was in the search of his residence.
Oh, okay.
The search warrant was for the defendant's residence.
Got it.
During the execution of that search warrant, the law enforcement officers found liquid methamphetamine in the freezer of the defendant's refrigerator in the house. They found numerous bags of marijuana. They found evidence of usage of narcotics, used drug pipes with residue, broken drug pipes throughout the household, as well as ammunition which fit the firearm that was located in the house, as well as several rounds of ammunition for a 12-gauge shotgun. Your Honor, the government submits that all of these facts indicate that the defendant is a danger to the community and a flight risk. the government will announce that the government does intend to file a superseding indictment with the next grand jury, which I believe sits next week, in which the government will be bringing the distribution charges as well as 924C charges for the possession of a firearm in connection with a drug transaction. Additionally, Your Honor, the government would submit that there is a question about the veracity with which the defendant filled out his affidavit for appointment of counsel. The government notes in the pretrial services report that the defendant does discuss having some silver. During the search of the defendant's cell phone, there were numerous bars of silver found on that particular cell phone, which are referenced in various text messages on his cell phone. And the government had somebody look at those bars and to get a rough estimate of the value. The government believes that the defendant has, at least in the recent history, had possession of silver that had a value in excess of $400,000. In addition to that, Your Honor, the government knows that the defendant, again in the recent history, has a bank account. It's at a bank in Tulsa, Oklahoma, and in the fall of 2012 withdrew in excess of approximately $15,000 cash from that account. So, Your Honor, there are some real questions that the government has with respect to the veracity with which the defendant answered the court's financial affidavit.
Of course, the government doesn't know what's on the financial affidavit.
No, it does not. However, I'm assuming that if there is a $400,000 declaration that he probably would not have court-appointed counsel at this point in time. So we do not know what's on there. The government does, if the court is inclined to issue a bond, the government does request a hearing for that on the assets that would be posted for the bond. In addition to that, Your Honor, the government would also request that the defendant notes that, or claims that he has income of roughly $4,000 to $5,000 a month, although he hasn't worked for several months. The government would request that the defendant be, as part of any bond consideration, be required to produce copies of his federal income tax returns for the last 5 years to show what income, if any, the defendant has, to verify the representations made to probation, or to verify the representations filed in his affidavit. The government would also note that the drug paraphernalia found in the defendant's residence was such that it would suggest that the defendant and or others who frequented the defendant's residence were fairly regular users of methamphetamine and marijuana. And combination of all these events makes the defendant a flight risk. In addition to those facts, the defendant has informed the arresting officer from ATF that he has taken steps necessary to revoke his American citizenship. As such, it's the government's understanding that in doing so, a person doing so is to indicate to the government the country for which he is placing some type of pledge in order that the defendant may be removed and be associated with a citizenship of a particular country. Upon revocation, if they don't do so, that person is subject to removal and I got this from Mr. Anderson, but it's my understanding, they're subject to removal to a place of designation by the government if the defendant does not make his own designation. So for all of these reasons, the government believes the defendant is a flight risk, the government believes he is a danger to the community, and the government requests detention.
Mr. Friend.
We'll start with the last point, Your Honor. I think you previously found that the government placing somebody outside the jurisdiction of the court is in fact on the flight list. I really don't know what was on Mr. Rush's cell phone. The government's certainly not shared that with me. I can tell you I've got multiple pictures of the Rocky Mountains on my phone, and yet I own no land in Colorado. I think my wife wishes. Mr. Russian does have some criminal history. Most of it could very fairly be described as ancient. And yet, in all of that criminal history, there is absolutely no indication that he's ever failed to appear for court or that he's ever violated a condition of any bond that has been set for him. It is my understanding that in the prior federal case, he was allowed to voluntarily surrender to the Bureau of Prisons, and he did so at the designated time and place. I have not yet been provided a copy of the search warrant that was executed at James' residence back in November, but it's my understanding that he was arrested and released, and then he has been out on bond, free on the street since that time. James also advises me that based on the nature of his work, it's seasonal. So he works when the weather is good, primarily doing concrete work, some welding, and he saves his money. And then he lives off the money when the weather is bad. The recent weather would indicate it would be very difficult to work on. So the fact that he might have at some time in the past withdrawn his savings from a bank account, I don't think should be considered by the court as anything nefarious. So we believe that there are conditions under which he could be released where he would be neither a danger to the community nor a flight risk. Any of the serious criminal history is quite ancient. And other than that, what we're looking at is arrests with absolutely no charges, or at the most, well, the assault in 2006, Your Honor, was a Class C misdemeanor, carrying a maximum sentence of 30 days in jail. But that has been the most recent conviction for Mr. Rushing. I believe he was also out on bond in his prior case and had no violations. So we believe not only would an OR bond be appropriate in this case, but he would not be a danger to the community nor a flight risk.
Anything further, Mr. Metzger?
No, Your Honor.
There is no presumption in this case, is there?
There is no presumption currently.
I consider the kind of the most important pieces of this to be really two things. One, which the defendant may not be in a good position to respond to, which are the circumstances surrounding the current offense, starting with, and the government, I know, is generally in a much better position to kind of make proffers about that often than the defense is to defend it. That seems to me to be important, perhaps more important than the defendant's actual criminal history, which I agree with a lot of what Mr. Fleming said about it. Some of it's pretty old, but not unserious. But the other piece of this is that I have concerns about Mr. Rushing's intent or willingness to honor and abide by the court's orders and pretrial services supervision. This partly, I admit, stems from Mr. Rushing's own view of the authority of this court. During his first appearance, he did not even concede that he was appearing personally in this court, but that he was appearing on behalf of and the legal underpinnings behind that. I'm not holding that against him. I'm not going to hold his politics against him or his adoption of some of those legal underpinnings. But I am concerned about the defendant's recognition and comportment and willingness to comply and cooperate with the authority of this court. And, Mr. Friend, I'm saying that to give you an opportunity to either address that question or to have your defendant address it. I'm not going to issue a bond order in this case that simply results in the defendant deciding that this court doesn't have any authority over him and he can do whatever he wants, which is the impression that the court got during the first appearance. And so, this court's ability to send the marshals after him doesn't satisfy that concern. If anytime I think someone is simply going to be unwilling to comply, then I don't put them on bond. And so I need to understand the defendant's position in that regard.
Can I have a moment, please?
Please. Mr. Friend? Oh, I'm sorry. I thought it was your turn. Do you have any comment about those concerns, or does your client?
Your Honor, I can understand your concerns, but I had an opportunity to visit with James last week, and again, right now, he understands how serious this matter is potentially, and he assures me that he would follow any orders that the court might set with regard to his bond, and I think his past history with compliance on release would back that up.
And what is the defense's position on this court ordering a cash bond for release?
Well, Your Honor, I think it'd be very difficult for him to make a cash bond while he's in custody. He's advised me that, and I couldn't find the case on the bond report, he has currently had, with the assistance of friends, a cash bond posted in Crawford County that he's due to appear on in March. So,
was that a surety bond or a cash bond?
I believe it was a cash bond, Your Honor, that friends had helped him post, a not insignificant amount. So I don't know to what extent he's got the resources to post a bond right now. Obviously, it becomes much more difficult when you're in custody.
And those concerns were among the reasons why I appointed counsel. The defendant is really kind of handcuffed, I understand, from engaging some things. But I'm going to put the defendant on bond. I think I think his criminal history is such that I think, notwithstanding his comments to this court, I think he's entitled to that. I'm concerned most about the circumstance surrounding the present offense, which are things the defense isn't in a position to defend right now, and which are also there are matters that are legitimate to consider, but they aren't consistent in some ways with his recent history. And I'm going to give him a chance to, I think, go on bond and demonstrate his respect for the court pending the dealing with these charges by the district judge. I am going to require cash bond as part of the court's order in the amount of $10,000. If he's not able to do that, then I'd be willing to consider later some alternative proposed by the defense. I'm not interested really in ordering a surety bond, but I am going to order a cash bond in that $10,000. I'm going to set some other conditions which I will go through with the defendant. So give me just a minute to look at some of the paperwork. My memory is the defendant doesn't have a passport. Is that right?
He does have a passport.
He does have a passport, so I will need that to be surrendered.
He's indicated he's willing to surrender, and I don't believe
I see that in the reports.
he even knows if it's valid at this point.
I understand. I intend to, if I restrict the defendant's travel to the state of Kansas, is that going to interfere with his ability to earn a living based on where he lives? I'm going to order, of course, that the defendant possesses a firearm, which is illegal for him to do anyway. And Mr. Durbin, you're not going to take the position that you have a right to do that, notwithstanding my order.
Pardon me, Your Honor, it's Mr. Rush.
I'm sorry, Mr. Russian. It's been a long afternoon, sir. Mr. Russian, you're not going to take the position you have a right to possess a firearm, notwithstanding my order. Okay.
No, sir, not at all.
Your Honor, if I might believe, the statute actually reads firearm or other dangerous weapon.
Right, firearm, destructive device, or other weapon.
Which statute, Your Honor?
Well, no, that's not a statute. It's what the bond form reads. I was just correcting you. Okay. Is the government going to ask me to stay this order?
Yes, Your Honor. The government also has some additional requests.
Let me hear your additional requests.
Your Honor, I received an email from the Honorable Lori Fleming, District Court Judge of the state of Kansas, in which she reported that she and her administrative assistant observed Mr. Russian apparently surveilling the judiciary secured parking lot and was watching them as they were leaving that secure parking lot. Judge Fleming expressed some concern about her safety as well as the safety of the court personnel. The government would request that the defendant be prohibited from coming into contact or approaching either Ms. Fleming or Ms. Marianne Forsyth, Judge Fleming or Ms. Marianne Forsyth, from a distance of at least 300 feet. In the defendant's political status, he is a frequent filer in the Crawford County Courthouse. I don't think this court can prohibit him from filing documents, but given the expressed concern and the oddity of the defendant appearing to have the court and personnel under some type of surveillance, the government believes that such a restriction would be reasonable in this scenario.
Have you shared that email? I mean, you didn't present this fact with your proffer on the case in chief.
I did not present it as part of the proffer, because it is an expressed concern and an observation, and so I didn't think it was appropriate because there hasn't been the government's not representing that there was any type of visible threat, but just an appearance, and so I didn't think it was an appropriate argument for the government to make in a request for detention. But I do think it's an appropriate item to be considered by this court on the defendant's terms of conditions of release. The government would also request that and the government can provide the names, but that the defendant nor any of his associates have contact with any witnesses in this case, to include the two young women in Joplin, Missouri.
Well, of course, I can't order someone other than the defendant. I can order when no contact would mean either him or anyone on his behalf.
Right.
So, and I'll order that. I'm not sure how to how to protect the state court judge without keeping him out of the courthouse. That's why I can't impose a yard restriction, a distance restriction on him from the judge without that won't include what county are we? What town?
I think it's Crawford County. I think it's Pittsburgh.
Yeah, so that. I mean, I don't know how to restrict that contact without keeping him out of the courthouse. I mean, I couldn't years ago restrict him within 300 yards of the judge. The Crawford County Courthouse is not that big. I don't. I mean, frankly, evidence concerning this concern might have changed my attention.
I understand that, but and that was a judgment call the government made.
Yes, Mr. Friend.
What Mr. Metzger has presented is the unsubstantiated guess of a state court official that at the worst alleges my client was in a place where he had the legal right to be, obviously observing something that was in plain view. As the court is well aware, and many of my clients who are serving long terms in federal prison are well aware, observing something in plain view is completely legal. I would suggest if Judge Fleming has a true concern, that would be best addressed through the state court system. But I would suggest to you that it would be unconstitutional to give such an order because, as you've recognized, it would deny him the access to the courts. But if Judge Fleming or her judicial assistant has a legitimate concern about their safety, that is something that could have been addressed well before now and in a very appropriate forum, which would be Crawford County District.
So how would you suggest such an order be worded, Mr. Metzger? I don't agree with Mr. Friend that I don't have the authority to order some kind of restriction. I think I do, but the logistics of doing it seem to be a difficulty for me.
Your Honor, if the defendant desires to file a pleading in the state district court, the defendant can designate another person to do the filing. We do it all the time. Any lawyer can file anything. Somebody, if he has a pleading that needs to be filed in an existing case, he could mail it. If he has a pleading to file in a soon-to-be-filed case, someone can file it. And that would not deny the defendant access to the state court system, but it would grant the court personnel at least some degree of comfort in the work environment.
Your Honor, if I might inquire, if this is such a concern, why hasn't Mr. Russian been previously banned from the Crawford County courts?
Okay, here's what I'm putting in the bond. I mean, obviously, if I had evidence in this hearing that was really going on, I wouldn't release it. I am going to put in the bond that the defendant shall not harass, intimidate, or stalk any state court law enforcement or judicial personnel. Now, if that seems vague, it is, which means that if someone claims that the defendant violated that, we're going to come back to court and find out if he did. And if that's what the evidence shows, then I will revoke the bond and put him in confinement. I think, and so I would suggest to the defendant that he not do anything that might even be interpreted as harassing, intimidating, or stalking a state court, state law enforcement, or judicial personnel. And that doesn't put anyone where they want to be, but that's what I'm going to say in the bond report. his acceptance of that term will be a condition of being released on bond. Will you accept that term, sir?
Yes, sir.
I've added that he can't have any contact with anyone who's a victim or witness in the investigation or prosecution of the case. Any other terms?
Yes, Your Honor. The government would request that the defendant be prohibited from disposal of any asset with a value of $1,000 or more without prior approval of probation or the court. Specifically, the government's concerned about the defendant's, if in fact the defendant has $400,000 in silver that can be readily converted to liquid assets, $10,000 bond is not very significant, particularly given the length of time, jail time, that this gentleman is facing in relatively near. Well,
I mean, that condition doesn't contribute to either the safety of the community or the defendant's flight risk. I'm not going to work on the government's investigation regarding his assets with this bond. I won't impose that condition.
As part of the defendant's request for bond, it's my understanding, and forgive me because I don't recall it off the top of my head, but that there is a process by which the government can request a bond, a hearing to determine the nature of the assets available to the defendant in the posting of bond, and whether or not the posting of a bond is in fact adequate to ensure the defendant's appearance at a bond. And that's really what the government is driving at.
I understand. I mean, this is that hearing. And so, I understand the proffer you've made about what you think things are worth, and I sort of took that into account. I also kind of took into account that we need cash and that we can't, I don't know what he can bring up here. That certainly isn't a determined amount, but I've taken that into account. In other words, I accepted your proffer to the extent it's still just a proffer. And I agree with you if I thought he had a boatload of cash someplace that was a lot more along the lines you're saying, then I might impose even a greater bond. And so I may not have that amount right, but this is the hearing for doing that. The defendant hasn't really offered any proffer concerning those numbers. So are you arguing that I've set too small a bond based on that information?
The government would submit that you submitted too small a bond.
Mr. Friend, what do you think about that? If I set too small a bond?
Well, Your Honor, I think you described Mr. Russian's largest impediment to release would be following the court's conditions. I think he might see it as the ability to post $10,000. So we lightly disagree that the bond is too small.
Well, Mr. Metzger's concern is that money isn't enough to dissuade him from violating it based on the amount of money he may have. In other words, not the difficulty in posting it, but whether the bond performs its job of serving as a deterrent against violation of the bond.
Every once in a while, we have very wealthy people who are sitting in Mr. Russian's seat that have substantial assets that are granted OR bonds. So I don't know that the extent of his assets should really have any bearing.
Well, I think it certainly has a bearing. But you don't want to make any counter-proffer concerning that information or anything at this point?
No, Your Honor.
I'll leave the bond where it is. And you want me to stay this? I would stay it for the purpose of filing an appeal.
Yes, sir.
I will stay it until this is Monday, until Wednesday morning. That'll be adequate.
Just so nobody's surprised, there could be additional charges filed.
Well, and of course I have to consider the ones that are in front.
That's correct. But I just didn't want anybody to be surprised.
So what I'm going to do is I'm going to stay the order until, obviously until the bond's posted, but also until Wednesday morning at 9 o'clock. If the government files an appeal of my order placing you on bond, then that will stop my order until the district judge rules on the appeal. So I'm staying it it's basically to give them a chance in the next 24 hours if they're going to file an appeal. Mr. Russian, you've heard about a lot of these conditions that I'm ordering set. One is that this is a secured bond in the amount of $10,000. It means you have to actually pay that to be bonded out. You have to deposit it, not pay it, but deposit it to be returned upon your compliance with the bond. So you'll forfeit the bond if you violate the terms of the bond or abscond. While you're released on bond, you may not violate any federal, state, or local laws. If the collection of DNA samples authorized by law, you have to cooperate with that. You can't change your residence or telephone number without first advising pretrial services. You must appear in court for all hearings in this case. And if you are convicted and sentenced as a judge, then you must surrender to serve that sentence. This will be a supervised bond, which means you'll have to report to and cooperate with supervising officers and pretrial services. You'll have to surrender your passport to pretrial services. I'm not going to stay the bond pending that, because you'll probably have to go find it and give it to them, but you'll have to get them to them right away. Your travel is restricted to the state of Kansas. You may not have any contact with anyone who's a victim or a witness in this investigation. And that certainly includes witnesses that are part of the whole story that the government just told, regardless of which parts of it you agree with. You may not possess a firearm, destructive device, or any other weapon. You may not use alcohol excessively. You may not use or possess any kind of unlawful drugs. You'll be tested for drug use during the bond. If the pretrial services decides that some kind of treatment or program are appropriate, you'll have to cooperate with that. Any contact of any kind you have with law enforcement must be reported to pretrial services. And to the extent you're able to help pay for testing and treatment, you'll have to do that. That's something pretrial services will help decide. And you may not harass, intimidate, or stalk any state court law enforcement or judicial person. If you violate any of those conditions, then a warrant will be issued for your arrest, and you likely will be back in confinement pending the trial of this case. And the bond will be forfeited. If while you're released you commit a federal felony, then in addition to whatever penalty that felony may otherwise carry, you can get an additional 10 years because it's committed on release. An additional 1 year if it's a misdemeanor. It's a crime to obstruct the investigation of this case, to tamper with evidence or interfere with witnesses in any way. It's a crime to fail to show up for hearings when you're supposed to. I'll send the specific bond out for you to review. Do you understand those general terms?
Yes, sir.
And you agree to comply with those?
Yes, sir, but I don't think I'll come up with the 10,000.
Well, that would make the whole thing moot.
Oh.
I'll send that out for your review and signature.
Yeah, French, please.
Please. Defendant has signed the bond, which I've approved. I ordered his release under the terms of the bond. That release is stayed until the cash bond is posted, and is additionally stayed until February 26th at 9 a.m. For possible appeal. If that appeal is filed, of course, then the release would be delayed until at least until the resolution of that appeal. May we proceed to arraignment?
Yes, Your Honor.
Mr. Rushing, we talked at your first appearance about the nature of the charge against you in this case, which is which is being a felon in possession of a firearm and in possession of ammunition, and that there's a property forfeiture count. You understand the claims against you in this case?
Yes.
Do you wish to have, you have the right to have the indictment read to you. Do you need us to do that?
I don't need it read to me, but all the numbers I don't understand what they are.
Okay.
No.
Okay. I'll now ask you how you plead. The only plea I can accept at this time is a plea of not guilty. How do you plead?
Not guilty.
Showing a plea of not guilty. Judge Melgren has this case, so issue a scheduling order governing the case. Anything further on this matter, Mr. Metzger?
No, Your Honor. Thank you.
Mr. Friend?
No, Your Honor. Thank you.
Thank you. We are adjourned.